I am Paul Harris, filling in for McGraw today. Thanks for listening. You can follow me on Twitter at Paul Harris Show and listen to me Friday afternoons between 3 and 6, the Friday edition of the Large Morning Show in the afternoon. Tomorrow afternoon, my guests will include David Steinberg, the man who's doing the interviews for a Showtime series called Inside Comedy, which last week had Louis C.K. and Bob Newhart on it, and this past Monday night had Tina Fey and Judd Apatow on it. David Steinberg is a guy who started out as a stand-up comedian 40, 50 years ago. Once did a skit on the Smothers Brothers show that almost got the show canceled before it eventually got canceled, and has become one of the top sitcom directors in the last decade or two. So he'll have some stories to share. Also, I think he appeared on Johnny Carson's Tonight Show more than anybody except Bob Hope. So David Steinberg will join me tomorrow afternoon in the first hour of the Friday edition of the Large Morning Show in the afternoon. That, of course, assuming that we can make it through Snowmageddon this afternoon and make it to tomorrow afternoon. All right, now, the big story of the last week or so, of last week rather, was the Carnival cruise ship Triumph. CNN, of course, had coverage from land, sea, and air. We had coverage from watching CNN's coverage. That's how our KTRS coverage was coordinated. We watched CNN, and then we talked about it on the air. Less than 24 hours after the Carnival cruise ship Triumph returned to port, the first lawsuit was announced. The first of the, I'm sure, many lawsuits to come. And yesterday, a couple named Matt and Melissa Cruisin', how perfect is that? They're suing a cruise company and their name's Cruisin'. Their lawyer announced that he is beginning a class action lawsuit against Carnival Cruise Lines and hopes to get as many of those 3,000 customers on board with the lawsuit as possible. I thought we would talk about this a little bit with our legal analyst here at the Big 550 KTRS, Scott Sherman. Good morning, Scott.
Good morning, Paul. How are you?
Good. So, since there already was a lawsuit filed last week, why does this lawyer get to decide he's doing a class action lawsuit instead of last week's lawyer?
I guess because there are 4,200 other people, besides Cassie Terry, the very first plaintiff to sue Carnival, that think that being exposed to raw sewage and disgusting, undercooked, and rotting food and all of the other joys of this Triumph, the insult, comic cruise that they were enduring as they were being towed through the Gulf of Mexico was probably ripe for litigation.
Now, I know Carnival has offered these people their money back.
Money back.
Like $500.
And $500.
And I think they get a coupon for another cruise.
And come on back.
Yeah, which none of those people is ever going to take.
Well, the toilets might work next time, and we might not have an engine fire, which apparently has happened 10 or 15 times in the last dozen or so years. Not that that would matter to anybody that was going to go on these fun ships, because there's so much fun.
Well,
fun.
I'm not a cruise person. I've never been on one. I can't testify to what it's like to be on one. I get motion sickness, so I'll never be on one. But I know plenty of people, and I've talked to some in just the last week, and I said, after a story like this, would you ever go? And they said, well, yeah, I would go, because, you know, it's like not flying after a plane crash. Just because one happened, plenty of people go on cruises all the time and have a wonderful time.
I am one of the people that has actually been on a cruise, and I enjoyed it.
Okay.
It was fun.
Yep.
It wasn't the greatest experience in the world, because some of the things you want to do when you're going through the Caribbean is spend the night on the beach and watch the sunset. You don't get to do any of that stuff.
Okay.
They hustle you on and they hustle you off, and you sail at night. But for an all-inclusive trip where you really want to get just a sample, that's a nice thing. It's if you are a foodie, going to a smorgasbord at some kind of a cafeteria is not fine dining, but if you've never really experienced different kinds of food, it's not a bad way to get a sample. So it's not a horrific event.
All right. Well,
however, sewage.
Yeah, it was for these thousands of people.
Yes.
So tell me about this from the legal standpoint.
Okay.
What is it that they're going to go after them for more than just, I want my money back? And what are they entitled to?
Here's what the Cruisins and the other cruisers who are going to be suing Carnival are going to try to do and what they are limited to do. Because what they are limited from doing is really important. But here's what they are claiming. We, the cruisins, were exposed to some very disgusting conditions which were potentially hazardous to our health. You can get hepatitis. You can get dysentery. I mean, you can get a whole host of bacterial infections and diseases from the rotting food and the other stuff.
Did they?
They have not been diagnosed with it, but they could.
Okay.
So we don't know yet.
All right.
We are the cruisins. We've just got back.
Yes.
So their lawsuit, their complaint is, Carnival, you knew or should have known that Triumph, the insult comic cruise, had problems. In fact, just a week before, instead of towing him into port, I guess ships are she, towing her into port and checking on problems that were in the engine room, you set her back out to sail with 4,200 people on, and oops, a fuel line in the engine caught fire and took out all the power.
Yep.
So that negligence, being Carnival, you should have been more careful. You're more concerned about making money than you are about the safety of your passengers. You exposed us to this unreasonable risk of danger, that being a ship that doesn't move in the middle of the Gulf of Mexico, and toilets that don't flush, and food that can't be cooked. So your negligence, Carnival, caused the potential of us getting sick, a physical injury.
Yep.
Now, those specific allegations are really important because a lot of the relationship, the legal relationship between Carnival, it's not just them, it's all cruise lines, and as we'll talk about in a little bit, a lot of businesses and their consumers, their customers, is dictated by the Carnival Cruise ticket contract. And I have read this many times.
Have you?
Read it this morning. I have a copy of it because it's so beautiful.
Now, this is to me one of those things that's like the terms of agreement when you download iTunes. You always have to click on agree, and everybody scrolls right to the bottom and clicks on agree and doesn't read the whole thing. Or when you fly, there's a whole thing written out on the inside of your ticket, which nobody has anymore because we have e-tickets. But there are all sorts of small print things that lawyers for the airline or the software company or whoever it is that you're doing services through, that, you know, get a rental car. There's a whole contract. Everybody just goes to the bottom and signs.
Yes.
Nobody reads that, and I'm sure the same
printed on bathroom tissue.
Yeah, but
no one can read it, and they don't read it.
But it didn't matter what they printed
phones,
it on.
Yes.
Yeah, but I mean, when it comes to a Carnival cruise ship, is there something on there that says, look, if something goes wrong here, we'll give you a refund, but that's it. That's all you're entitled to.
Is there something? There's everything. These people are if they're not the inventors of it, they're the perfecters of the liability limitation language in a contract.
Okay.
And here's the deal. You want to go on a Carnival cruise? You want to go on any cruise? You better sign this thing, and you're not going to be able to negotiate it. So here's what it says. It has 16 clauses in it, and it goes through cancellations and delays and baggage handling and loss of luggage, and if you get too drunk and all kinds of other stuff, you get arrested in a port of call. But the four main ones that pertain to this incident and the Costa Concordia incident, which is not nearly as funny because 22 people died in that in Italy, and other incidents that occur on a Carnival cruise, because we're talking about the Carnival cruise ticket, are the following. One, Clause 7, the famous Clause 7, which says we can tow the cruise ship to and from and in and out of ports. So the first thing people were saying is, how come there's this tugboat? How come they didn't send out another ship? How come they just haven't, taken these people off of this thing? Why are they tugging it at 2 miles an hour? Well, it's in Carnival Cruise Ticket, Section 7C. Thank you very much. For any reason, including but not limited to safety, just because we think it might be fun to tow you around the Gulf of Mexico.
I'm sure the Carnival would say that that's really in there because we go to some ports of call where we can't motor in to the dock ourselves as a big cruise ship, so we have tugs that do that. Just like at the airport, there are sometimes tugs that go out and pull planes into certain gates because of crowding or for whatever situation. Same thing. So that's essentially what they're saying, right?
Well, that's what they say when that happens. What they say when the thing runs out of fuel or almost burns to death is, it's 7C, we can tug you through the Gulf of Mexico.
In the middle of the ocean. Okay.
For any reason whatsoever. So, okay, fine, they tugged it, they made it home safe. Now, the other three are really the interesting ones, and that are the clauses that relate to liability limitations, arbitration clause, and the no class action lawsuit clauses, which will be applied or at least litigated in this cruise-on case. Remember, the cruise-on case is one where not only are the cruise-ons claiming that they were exposed to all these horrific biohazards, but that the other 4,200 people on board are, and the cruise-ons, and through their lawyers, they're the best representatives for the procedure of justice to streamline and simplify this. They want to be everybody's lawyer.
So there is a clause in this Carnival ticket, which is essentially a contract between you and the company. When you buy the ticket, you are effectively signing it, because you don't actually have to sign the contract, but by buying it, there's the implicit signature that way.
Your agreement.
And you're agreeing, no matter what happens here, I'm not going to be part of a class action lawsuit against you.
That is the attempt in one of the clauses, Clause 3 of the Carnival Cruise.
Have you seen this before, and can that hold up in court?
Yes. In fact, the United States Supreme Court, just in 2011, had a case that came out of California involving AT&T cell phones. Now, on this a lot of this comes out of cell phone contract. You want to get a cell phone? They've got these clauses in there, no class action suits. They have arbitration clauses, so you can't go to court. But in that case that went to the U.S. Supreme Court, AT&T Mobility versus Concepcion, and he played for the Cincinnati Reds in the 70s, he's a shortstop.
Yes.
So in the Concepcion case, California has very strong consumer protection laws. And California had passed a string of laws saying these clauses that try to prevent class action lawsuits where consumers can't find lawyers to pursue a case for $30 for maybe a ripoff or an overcharge on taxes. If it's a free cell phone, they charge you for the tax, or if they overcharge you on your bill. Nobody can get a lawyer and file suit against AT&T for $30. No lawyer's going to take that. So for consumer protection laws in the state of California, we will consider any language in those purported contracts to be null and void against California public policy. Well, AT&T takes it all the way to the U.S. Supreme Court, and guess what happens? 5-4 decision, the anti-class action lawsuit language is okay. It's confirmed as part of the Federal Arbitration Act, which goes back to 1925. And essentially, the court, Justice Scalia wrote the opinion. Why wouldn't he be his favorite subject? And he said, no, there's nothing unconscionable about these. You can negotiate your way out of these deals. Well, good luck getting yourself a cell phone by telling your cell phone carrier that you will abide by the terms and conditions, except for the class action.
Yeah, try
part.
Crossing out some things in that contract and initialing them. See how that goes.
Yeah, you'll be talking with cans and string. So that case...
But again, the reason you'll never be able to change that as an individual is because you never actually see a contract that you negotiate with anybody. It essentially is, hi, I'd like to buy this iPhone. Okay, you want to sign up with AT&T? Okay, it's all done electronically in the store. You sign a thing electronically, or you sign your receipt.
Scroll down to the bottom and sign
and
here.
It's done. There's no negotiating. You don't buy the iPhone and go, okay, before I take this iPhone home, listen, Clause 16B has got to come out.
Right. And, of course, lawyers have cell phones, and they're not negotiating them
They're
either.
not going to the Genius Bar and working that one out. There ain't no geniuses involved in this.
Right. So here you've got now Concepcion, which says, hey, California, stick it. It's rock, paper, scissors. The feds, under the Federal Arbitration Act, they've got paper, and even though you've got rock, they cover you, and therefore, unless Congress changes the Arbitration Act to make these things unconscionable, at least with consumer-style limitations in class actions, no class actions if it says no class action.
Okay, so that's one of those clauses.
That's one of those clauses.
Let's go back to another one here, the part on the limitation on liability.
Yes.
Now, we always hear about tort reform people who want to have tort reform, mostly pro-corporate entities, want tort reform in this country because they fear that somebody's going to file a lawsuit and they're going to bankrupt America's corporations. And that essentially is what the limited liability is here. They don't want them to be able to sue Carnival for so much money that the company would essentially go out of business, right?
Well, that's the claim. And what ends up happening is a lot of the language that's in this Carnival Cruise ticket, and it's really comprehensive, and we'll probably get into it in a little bit, is the kind of language that a lot of the people that claim, like you said, that tort reform is a good thing, runs up against people's right to redress in the civil courts.
All right, let's actually get into it now. I'm going to hold off on the break for just a couple of minutes here. Tell me about what limitations you can have on this sort of liability. Again, where people's lives were in danger.
This is so good because Clause 11 of the Carnival contract specifically says that for people that have been on cruises, they have shuffleboard, they have volleyball, they have basketball, they have rock climbing, they have parasailing, they have all kinds of activities on board the ship.
Yep.
Very specifically in the Carnival Cruise contract, it says no liability for any activities involving sporting equipment or sports. So if you break your ankle rollerblading on a Carnival cruise ship, you're out of luck. But the other stuff is this. They want to send everyone to arbitration, meaning you cannot go to court, and that's part of Clause 11 and part of Clause 12, their arbitration agreement, unless it involves the negligence of Carnival or its employees within the scope and course of their employment, and it causes some kind of physical injury. So let's say this. You are sexually assaulted by a Carnival Cruise employee who is drunk and off duty because it's an intentional act and they're not within the course and scope of their employment. They're off duty. No liability for Carnival, even if they had hired someone that they knew was a sexual criminal predator. So Carnival hires somebody from a foreign country that has a criminal history, been to prison as a rapist, comes into a stateroom and rapes one of the passengers. No liability for Carnival.
Okay, that one's going to end up in court. But in this case, where's the liability for what Carnival did and didn't do in terms of the negligence of running the boat in a safe manner for their customers?
There is an ability here, and that's why the language of the Cruise On lawsuit is so important, that the negligence of Carnival in not maintaining its safety in its engine room was the cause of physical injury. You have to have physical injury because that is the only avenue you have in the Carnival Cruise Ticket Clause 11 with which to proceed against them in federal court in Miami where this was brought. However, they attempt in Clause 12 to take all litigation out of the courts and into arbitration by an arbitrator who is paid for and hired by Carnival Cruise.
Okay.
So they're trying to not only limit the amount of exposure by not permitting class action suits, trying to narrow the avenue by which you can pursue any action against them, even if they're negligent, but they're also tinkering with the idea of denying people their right to even have a jury trial and taking it to an arbitrator who, we all love our, alternative dispute resolutions, but where are they going to get their payments from? Well, the cruise-ons aren't hiring the arbitrator. The arbitrator rules in favor of a lot of passengers. Guess what Carnival's going to do to that arbitrator? Fire her.
Don't they just go to an arbitration company?
American Arbitration Association. But if you want the business, who's on retainer? The company is paying the arbitration company for these arbitrators. Now, that doesn't mean that they're in the tank, but let me give you a statistic. Do you know what the percentage is of in these types of disputes that go to arbitration involving consumers and companies?
I'm guessing it's not 50-50.
98% in favor of the company.
Huh.
So arbitration is not exactly court. And while this particular case, because it does potentially involve physical injury, may not be taken away and put into arbitration, as we've seen in Concepcion, and we're seeing in other cases, including a case that's going to be argued in front of the Supreme Court in March called Oxford Health versus Sutter. March 25th, there'll be oral arguments. every contract that you're seeing is potentially one where you could have a limit to what your access to the courts is, taking it out of court and putting it into arbitration. So, tamping down class action suits, it's right in the contract. Trying to take cases out of court and putting it into arbitration, it's right in the contract. And limiting the cause of action, or at least the theory of liability, it's right in the contract.
All right. I do have to take a break here. We're going to go to traffic in just a second here, and I got to do some commercials. When we come back, I want to ask you, what could their liability really be? What could the cruisins and other people who were on that boat who felt that they were injured by the experience of being locked up on this boat for 5 days without all the stuff that they thought they'd be getting, like, I don't know, flushing toilets and food, although without toilets, why would you want food? That's a whole other question. I want to know, what do you think they can expect out of this whole thing? So we'll come back and talk more with legal analyst Scott Sherman in just a moment. I'm Paul Harris. This is McGraw in the Morning on the Big 550 KTRS.